Hi everyone, in this video we'll talk about the remaining two ingredients of a representative suit, that is a suit of representative nature can be initiated in either of the ways, that is by either by court's permission or on direction of court. And the last ingredient, that is serving of notice. In our previous video we discussed about the object behind representative suit and we delve into the ingredients, and we also discussed elaboratively on the ingredient with help of leading case law. So you can go and check out our previous video on representative suit as well as other videos on CPC and other subjects as well. So starting with the third ingredient, we have a suit of representative nature can be initiated in either of the ways. And these ways are when on court's direction or by taking court's leave with the permission of the court of sub-rule 1 of rule 8 clause A. This talks about taking leave of the court, that is the party who wants to represent is applying before the court. He wants to initiate a suit, or he wants to defend in the nature of a representative capacity. So he asks the court for leave under subclause A. Under subclause B, the court directs, yes, you go ahead and sue or defend in the representative character. What we have. So now we'll ask the question, what is the proper stage to obtain permission? The proper ideal stage, talking from the perspective of practical litigation, it is before suit is being filed. There only we have to write in the plaint or in the written statement that we have to file in a representative capacity. Now, either there are provisions where the request is granted after filing, or even at the appellate stage, the permission is granted even then also. Now, another question is who has to apply for court's leave? In case where, let us assume two situations here. The first is where the plaintiff wants to sue in a representative capacity. There we have plaintiff applying. Second, where are numerous defendant and they are having same interest. So any of the defendant can apply for leave of the court or suing in a representative. Now the second ingredient is serving of notice. That is, notice must be issued to the parties whom it is proposed to represent in the suit. We have that wherever court grants leave, that is when court grant leave under subclause B, or the permission is sought under subclause A of subrule 1. So a notice of the institution of suit will be issued to all persons so interested. Those who are having interest in the suit, a notice will be issued to everyone. It will be done on plaintiff's expenses. Now there are two modes discussed here of service of this notice. It is either by personal service or by public advertisement. Public advertisement is in cases where by reason of the number of person or any other cause, such service, that is personal service, is not reasonably practicable. So in those cases we have public advertisement. Let us say we have 1,000 people who are there as a representative to the suit. What we discuss about numerous person here, that we have numerous person. If this numerous person is actually numerous, so then we have situation of public advertisement of serving notice. Now one of the reason why notice is important, it is because of res judicata. Res judicata applies here to rule 8. We'll discuss it more when we discuss res judicata. For the time being, just understand that the reason why notice is important, it is because of res judicata. Thank you very much for this video. In our next video of representative suit will be the final video of representative suit. There we'll discuss about addition or substitution of party, that is under rule 3. We'll also discuss about subrule 3. Subrule 5 will also talk about substitution of parties. Under subrule 4 we will talk about withdrawal or compromise, and we'll also discuss subrule 8A, and we'll conclude our representative suit with our next video. And those who want to know more about representative suit can go and watch our previous videos. Thank you very much and keep learning the law.